Page 16 and 21.
Two people caught in a very compromising position on someone else's driveway, and I mean very compromising. We're talking full nudity, exposed body parts, and they refused to stop when police arrived. But this public lewdness case takes an unexpected turn when the judge discovers one defendant is undocumented and drops an immigration bomb that could land them in detention for 6 to 9 months if they violate their bond conditions. Watch as this judge goes from lecturing about appropriate places for intimacy to delivering a stark warning about icy detainers that will make you understand just how high the stakes really are. This isn't just about embarrassment. This is about potential deportation.
Well, here's one we haven't seen in a while. Good morning.
Buenos días.
Buenos días.
Good morning.
Both of you are charged with public lewdness. This is a Class A misdemeanor. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On September 1st, 2024, officers were dispatched to 4220 Bissonnet regarding a criminal trespass incident. The police dispatch advised that the homeowner arrived at his residence and discovered a red Toyota Corolla parked on his driveway with 2 occupants inside the vehicle. The homeowner told the occupants to leave and they did not comply. The officer arrived at the location and discovered the red Toyota was parked on the resident's driveway. The vehicle engine was off, and the vehicle's front right passenger window was rolled down. The officer approached the vehicle and observed a female, the co-defendant, laying on the front passenger seat, and a male, the other defendant, laying on top of her. The front passenger seat was reclined all the way back. The co-defendant's lower body was nude with her vagina exposed. The other defendant's lower body was nude as well, with his erected penis exposed and touching the co-defendant near her vagina. Officers ordered both individuals to stop their actions and exit the vehicle. The individuals did not comply and they continued with their actions. Both defendants were detained.
Really?
Both defendants were detained. Both individuals were intoxicated with slurred speech and red glossy eyes. Both individuals could not keep their balance and needed assistance walking. Both defendants were secured in the back seats of the police vehicles. The homeowner said he arrived at home at approximately 1:15 a.m. and discovered the red Toyota parked on his driveway. The homeowner said that he did not know the individuals and he saw a male and a female kissing while sitting on the front right passenger seat.
Okay, let's break down what just happened here because the police report is absolutely wild. Officers responded to a criminal trespass call at 1:15 a.m. and found a red Toyota Corolla parked in someone's driveway. Someone who doesn't know these people at all. When officers approached, they found the female defendant laying on a reclined front passenger seat, completely nude from the waist down with her vagina exposed, and the male defendant on top of her, also nude from the waist down with an erect penis exposed and touching her near her vagina. Here's the kicker. When officers ordered them to stop, they didn't comply and continued their actions. That's right. They kept going even with police standing right there. Both were heavily intoxicated with slurred speech, couldn't keep their balance, and needed assistance walking. In Texas, public lewdness is defined as engaging in sexual contact or exposing your genitals in a public place or in a place where others are present and could be offended. This is a Class A misdemeanor, carrying up to a year in jail and a $4,000 fine. What makes this particularly egregious is that it wasn't just public. It was on someone else's private property without permission, which is also criminal trespass. The homeowner told them to leave, and they refused. This isn't a case of, oops, we got carried away. This is aggressive disregard for the law, property rights, and basic decency. The judge is about to find probable cause, and honestly, how could he not?
I am going to find that there's probable cause to go forward in both of your cases, and I would hope that you would recognize that this is something that's supposed to be a private event between both of you and not to display it to the entire world. I am now making it a condition on both of you guys not to consume alcohol or illegal drugs. I'm going to randomly test each of you. If I find that you're consuming alcohol, I'm going to put you in jail or illegal drugs. Likewise, I'm ordering you not to have sex in public. If you're going to have any kind of relations, do it indoors. Do you understand?
Sí, disculpe.
Tell me, are both of you United States citizens?
¿Ciudadanos estadounidenses?
Perdón.
¿Es ciudadano estadounidense, sí o no?
No, son muy grandes.
Mr. Vasquez, are you here with or without permission in this country?
Without permission.
Ms. Pacheco, are you here with or without permission?
Without permission.
Do you know what happens if you go to jail?
¿Saben qué es lo que les pasa?
Wait, did you catch what just happened? The judge asked about citizenship status, and Mr. Vasquez just admitted he's in the country without permission, meaning he's undocumented. Miss Paco has permission, so she's likely here legally on a visa or has some form of legal status. This completely changes the stakes of this case. The judge immediately asks, do you know what happens if you go to jail? And the defendants clearly don't understand the gravity of what he's asking. This is where the judge is about to drop some serious knowledge about immigration consequences. In the United States, when an undocumented person is arrested and booked into jail, Immigration and Customs Enforcement, ICE, is typically notified. ICE can then place an immigration detainer on that person, which means even if they post bond on a criminal charge, they can't be released. They're held for ICE custody. This can result in months of detention while immigration proceedings play out, and it often leads to deportation. The judge is setting up bond conditions specifically designed to keep these defendants out of jail because he knows what awaits Mr. Vasquez if he violates. Watch what happens next. This is about to get very real.
Puede pasar si van a la cárcel.
Sí, disculpe. Sí.
Do you know what happens if you go to jail?
Si va a la cárcel?
No saben.
No, I don't know.
Think.
Okay.
Piense.
Sí.
¿Qué pasa si te ponen en la cárcel?
Disculpe, señor juez, la verdad que cometimos una. Disculpe.
I'm trying to give you a warning,
Estoy tratando
and I want you to think
advertencia
about
que piensen
if you go to
que
jail.
Es un
van a la
castigo.
cárcel. It's
Es un castigo.
a punishment.
No. If you go to jail,
Si usted va a la cárcel,
immigration will find you.
ocasión lo encontrará.
They will put a detainer on each of you. You will be stuck in jail for the next 6 to 9 months,
6 a 9.
waiting for immigration to do whatever they're going to do to you. You cannot bond out, and you will be stuck there for about the next 9 months.
9
If you do not want this to happen, do not violate the conditions I've set forth now. This is the only warning you will get from me. I'm not going to do it again. If you're incapable of having relations indoors, then you'll be doing it in the jail.
Lo harán en la cárcel.
Do each of you understand?
Cada uno de ustedes entiende?
Sí, entendemos.
Yes, we understand.
This is one of the most powerful warnings I've ever heard a judge give in courtroom. Let's break down exactly what he just explained because it's crucial. If either defendant goes to jail for violating bond conditions, whether consuming alcohol, using drugs, having sex in public again, or in Mr. Vasquez's case, driving without a license, immigration will find them. ICE monitors jail bookings and will place a detainer, which is essentially a hold request asking the jail to notify IC before releasing the person and to hold them for up to 48 hours for IC pickup. But here's the reality the judge is describing. Once that detainer is placed, the defendants will be stuck in jail for the next 6 to 9 months waiting for immigration to do whatever they're going to do. They cannot bond out on the criminal charge because the immigration detainer supersedes the criminal bond. Even if they beat the criminal case, they're still detained on immigration grounds. This isn't theoretical. This happens every single day in counties across America. The judge is being extraordinarily direct and compassionate by warning them about this consequence up front. His message is crystal clear. This is the only warning you will get from me. I'm not going to do it again. If you're incapable of having relations indoors, then you'll be doing it in the jail. That last line is both a warning and a challenge. Can they control themselves enough to avoid deportation? We're about to find out.
Tom, so you're representing only this gentleman?
Yes.
Okay. Miss Pacheco,
Señora Pacheco,
tell me about yourself. Do you work?
¿trabaja? ¿Trabaja?
Sí,
Yes.
What do you do, ma'am?
¿Qué tipo de trabajo hace?
remodelación.
Remodeling.
Do you have children?
¿Tiene hijos?
Un-
One.
Where is this child?
Guatemala.
Okay. What kind of income do you earn?
¿Qué cantidad de ingresos recibe?
500.
500.
How much a month?
¿Cuánto el mes?
2000.
2000.
Do you have the ability to hire a lawyer, ma'am?
No.
Let's do this. I want you to fill out an application for me, and I'll determine whether you qualify for a court-appointed lawyer or not. As it stands now, each of you do not violate these conditions.
Ustedes no violan esa-
I will put you in jail. Do you get no more warning? I told them no more alcohol, no more dope, because they're intoxicated. Not only that,
Solamente
who's driving?
quien condució
It's a red
es
truck. Is that your truck
el rojo. ¿Es suyo? el carro?
It's a
or a
Corolla.
Corolla? No driving. You do not have a Texas driver license. I am now making that a condition as well.
Eso no-
Mr. Vasquez, if I find that you drive, likewise, you will go to jail. I don't care what your excuse is.
The judge is systematically building a wall of bond conditions to keep these defendants out of trouble and out of IC custody. Let's count them. No alcohol, no illegal drugs, random testing, no sex in public, and now no driving, because Mr. Vasquez doesn't have a Texas driver's license. Each of these conditions has a single consequence: jail time, which triggers the immigration detainer. The judge is being incredibly specific. I don't care what your excuse is. No, I needed to drive to work. No, it was an emergency. No, I only had one beer. None of that matters. This is absolute zero tolerance because the stakes are deportation. What's interesting is the judge's approach here. He's not being punitive. He's being protective in his own way. He's giving them every opportunity to comply by clearly stating the rules and consequences. But he's also making it abundantly clear that there will be no second chances. The tone is paternalistic but firm. I'm warning you once. I'm setting clear boundaries, and if you cross them, you're on your own. For Miss Paco, who has legal permission to be in the country, the consequences are still serious: jail time and a criminal record. But for Mr. Vasquez, it's potentially life-altering. The judge knows this, which is why he keeps repeating the warning. This is judicial discretion in action, setting defendants up to succeed while making the path to failure absolutely clear. Let's pause here and talk about something controversial that this case raises. The judge asked about immigration status in open court, and Mr. Vasquez admitted he's here without permission. Some people will argue the judge should never ask about immigration status in criminal proceedings because it creates a chilling effect. Undocumented people become afraid to report crimes, testify as witnesses, or seek help from the justice system. Others will argue that judges need to know immigration status to properly advise defendants about potential consequences of pleading guilty or violating bond conditions. So here's my question for you. Was it appropriate for the judge to ask about immigration status in this public lewdness case? On one hand, The judge used this information to give a detailed warning that could literally save these defendants from deportation by helping them understand the stakes of violating bond conditions. That's arguably compassionate and protective. On the other hand, Mr. Vasquez's immigration status is now on the public record, and if he hadn't disclosed it, he wouldn't be at risk of an IC detainer in the first place, though he'd also be unaware of that risk. Where do you stand? Should judges inquire about immigration status to provide better advisement, or should that information be kept separate from criminal proceedings? And what about the specific case? Were these defendants treated fairly, or should they face harsher consequences given they continued their actions even when police told them to stop? Drop your thoughts in the comments, because this intersects immigration policy, criminal justice, and personal responsibility in complex ways.
Guys, I will have you sign a reset with Victoria. Both of you will also, Mr. Vasquez, I'm going to have you come up and sign a promise with me that you're not to drive. After that, both of you will meet with pretrial, sign your bond conditions. And after that, Mr. Vasquez will release you to your lawyer. Ms. Pacheco, we will have you take a seat in the jury box while we review your application. Please, guys.
All right, let's wrap this up and analyze what we just witnessed in this extraordinary public lewdness case. 2 defendants were charged with Class A misdemeanor public lewdness after being found in an extremely compromising position, fully nude from the waist down, engaged in sexual activity, in a Toyota Corolla parked on someone else's driveway at 1:15 a.m. The homeowner, who didn't know them, told them to leave, and they refused. When police arrived and ordered them to stop their sexual activity, they continued, defying direct orders from law enforcement. Both were heavily intoxicated, couldn't maintain balance, and needed assistance walking. The judge found probable cause to proceed with charges that carry up to 1 year in jail and a $4,000 fine. But then the case took an unexpected turn when the judge inquired about citizenship status. Mr. Vasquez admitted he's in the country without permission undocumented, while Ms. Paco has legal permission to be in the United States. This revelation completely changed the stakes of the case. The judge delivered a detailed warning about immigration consequences if either defendant goes to jail for any reason, including violating bond conditions. Immigration authorities will find them, place a detainer, and they'll be stuck in jail for 6 to 9 months waiting for immigration proceedings, unable to bond out. The judge emphasizes is their only warning, and he won't repeat it. The bond conditions imposed were comprehensive and strict. No alcohol consumption, no illegal drugs, random testing, no sex in public. All relations must be indoors. And for Mr. Vasquez specifically, absolutely no driving since he doesn't have a Texas driver's license. The judge made it clear he doesn't care about excuses. Violation of any condition results in immediate jail time, which triggers the immigration detainer. Mr. Vasquez will sign a specific promise not to drive. Both will sign formal bond conditions with pretrial services. And Ms. Paco will have her application for a court-appointed attorney reviewed, since she earns about $2,000 per month in remodeling work. This case illustrates several important intersections in the justice system. First, the consequences of public lewdness aren't just about embarrassment. They're serious criminal charges that can result in jail time. Second, immigration status creates additional layers of consequences that can turn a misdemeanor into a deportation case. Third, judges have discretion in how they handle these situations, and this judge chose to be explicitly clear about consequences rather than letting defendants stumble into deportation unknowingly. Fourth, intoxication is often a factor in poor decision-making that leads to criminal charges, which is why alcohol consumption is typically prohibited as a bond condition. The judge's approach here is notable. He's paternalistic and stern, but also protective in warning them about immigration consequences they might not have understood. He's giving them every opportunity to comply, while making the consequences of noncompliance absolutely crystal clear. Whether you agree with the judge's decision to inquire about immigration status or believe it should be kept separate from criminal proceedings, there's no denying this case shows how interconnected criminal justice and immigration enforcement have become in America. If you found this case as unusual and thought-provoking as we did, make sure to hit that like button. Drop your thoughts in the comments about whether the judge handled this appropriately or should have taken a different approach. And don't forget to subscribe and turn on notifications for more courtroom breakdowns where we analyze the legal complexities, ethical dilemmas, and real-world consequences of criminal cases that intersect with immigration, public decency laws, and judicial discretion